Okay, it's Friday afternoon. I'm William Pelarenos. We are here at WRMN 1410 AM in lovely downtown Elgin. Little nippy today. Did you give out the weather, Matthew?
You know, I did not. I had an interview and then I talked about a bunch of other things.
I heard your interview on the way in. So real quickly, let's tell them the phone lines are open and then go with the weather.
All right. Phone lines are open here, 847-931-1410. You can also text us at 505-926-1410 or check us out, youtube.com/WRMN radio.
Now tell people what the weather is, and then I'm going to go to my broadcast.
All right. Weather today, forecast mostly cloudy skies early, partly cloudy in the afternoon, which is right now a high of 44 is in that forecast. It drops down to 32 coming up for tonight. Current temperatures as of right now are at 43, so we're almost at our high.
On the way up here, I encountered some heavy winds at 990 westbound, so there must be at least 29 to 30 mile an hour winds gusting.
Yep, 10 to 20 miles per hour predicted today, even higher later today. So
winds can cause a lot of damage to your vehicle, even to your home. I found a gutter spout the other, like 10 feet of gutter that didn't belong to my neighbor and didn't belong to me. It had blown from who knows whose house. You know the white gutters?
Oh, yeah.
The rain gutters.
Ours blew off, too.
Yours blew off, too? Maybe that's yours. I'll bring it.
No. It blew
It's
all
white.
that way.
Is it white? Is it about 10 feet long? Yeah. That's it, Matthew.
It's mine. No.
It blew from Elgin to Chicago. What can I say? Hey, we're on fire today. All right. Sorry, let me clear my throat. Last year when I was doing this show, I was asked, one of the listeners asked, she was watching General Hospital soap opera on Channel 7. Mm-hmm. There's only 3 soap operas left. So General Hospital is one of the popular ones, and there's Young and the Restless on CBS, and I think Bold and the Beautiful is the other one. So I don't follow soap operas. I haven't watched General Hospital for 40 years, since 1979, 1980, somewhere there. But she was asking about this trial that was going on in the episode, and if it was, you know what, accurate. Mm-hmm. Is this how lawyers interact? Mm-hmm. So I started watching it. And what I did, I started DVRing, and I was skipping all that lovey-dovey in the afternoon and just going to the courtroom segments. I wanted to see the trial. Mm-hmm. Just like a juror, you're coming in there blind. Yeah. And you're only there. You don't know none of the background. So I started watching this. And this week, they had a trial running. It was an attempt murder. It seems that a congressman was shot in the back in his home 2 times. That's the plot. Didn't happen in real life, but it's the plot. Mm-hmm. So I'm just giving you a little background so I can give you my synopsis on the take. So he's shot in the back 2 times. His name is Drew Kane, a.k.a. Drew Quartermain. Quartermain's the big family on that show. Mm-hmm. So he's shot in the back, and the person that they arrested with very little evidence is his ex-girlfriend, who subsequently he married.
Huh, okay.
But we're going to get deep in on this. So the question was, how accurate are these television programs with the courtroom stuff? Mm-hmm. So this is the second trial I've seen on this show. The first trial on cross-examination. You understand what cross-examination is? Okay, so one side, either the defense or the prosecution, brings on a witness. Whoever brings him on, that's direct examination. Mm-hmm. When the opposing counsel asks them questions, that's cross-examination. Mm-hmm. So if the state brings on a witness, they do direct examination, ask them questions, then the defense does cross-examination, or vice versa, depending if the defense brought in. Mm-hmm. So in this week's episode, several things happen. The trial is going on. The defendant was not going to testify. And that's a tactic that a lot of lawyers use because a lot of people are not good under questioning. Even innocent people have confessed to crimes they haven't committed. Mm-hmm. So it ain't hard to break down on the stand and just lose it. Yeah. You understand where I'm coming from?
I understand. Yep.
So the lawyer makes a common strategy. You're not going to testify. She has to raise reasonable doubt. Now, she's the defense attorney. That my client did not do this. Just reasonable doubt. Doesn't have to prove her innocent, just reasonable doubt. The state has to meet their burden beyond the reasonable doubt. And that's what they're moving with. So she gets an anonymous note that there was another witness to this shooting, that she saw, that the witness saw another suspect there. So she's going to try to shift the blame to another suspect. So what she does is she does a bluff. There was no video. She brings on that suspect, and she has a folder that says, video footage. There was no video footage. The person got scared and told the truth, which is an interesting tactic. Mm-hmm. But before that, she brings in another person who she thinks did not have an alibi for that night and had motive to shoot the congressman. And she starts asking him questions that she does not know the answers to. That's an unwritten rule among lawyers. Never ask a question that you don't know the answer to. You do not want to be surprised in front of the judge or the jury. Mm-hmm. What they do is they do discovery. And that's getting all the facts and information that's in the police reports and the videos. And then you move forward with this. And the state creates a house of cards, and the defense attorney is trying to tear those cards apart, knock down that house of cards to get an acquittal either through the judge in a bench trial or in a jury trial. In a bench trial, it just means the judge makes a decision of guilt. Mm-hmm. In a jury trial, the judge awaits the jury's decision. If they acquit, that's it. If they convict them, the judge will decide the sentencing. There you go. So you know where that's going. You got a caller.
We got a caller. Hi, welcome to the show.
Hey, how's it going?
Hey, good, thank you.
Yeah, my name is Patrick. I'm calling about last week. You guys had somebody on, an officer that was shot and wounded in the line of duty.
Yeah, we've had two of them. Which one are you referring to?
Well, I think I heard both of them. But last week, the gentleman that was wounded was a police officer. Yeah. And I got a couple of questions. Well, first I want to say God bless him for his service, because if it wasn't for the police officers, God knows this country would be terrible. So I thank him for his service, and I hope he gets better, and I hope they convict the man and send him to prison for life. But so with that being said, I heard that that guy is still awaiting trial 5 years later, and he is incarcerated, probably in Cook County Jail, correct?
No, it happened in DuPage County. The one you're talking about, it occurred in the town of Bensenville. He's at the DuPage County Jail awaiting trial. But from what I understand, there's a psychiatric evaluation going on with the court system right now as to his mental stability.
Okay, I got it. But he's locked up somewhere in DuPage County, either the county jail or a mental hospital. So I guess my question is this. Last year in January, in a town called Friendship, Wisconsin, if you Google it, there was a man by the name of Rick O'Hara. I believe it happened on January 5th or January 6th. And he was in a bad state of mind. He was drunk, and he left his house, and he wanted to do the suicide by cop. And he got in his truck and drove away. And so when they stopped him, he unloaded a 9mm. He didn't hit any of the officers, and the officers returned fire. Now, he himself was arrested with intentional homicide of a police officer. You can Google it. This is true. And then, so he went through a lot of the hearings and the same thing with the mental, see if he was, okay for bond or whatever. And then whatever happened, I don't know how it happened. How was he able to get released on bond, $100,000? He's out on a $100,000 bond right now. And I thought that the law says you cannot be a danger to yourself, society, or police officers. And obviously, he's a threat to everybody. So how does the system allow somebody like that to make bail?
That's great. That's a twofold question, actually, Matthew. Look up the case because I'm not familiar with it, but I'm going to answer your bail question. Okay, that's Wisconsin, correct?
Correct. Friendship, Wisconsin.
Wisconsin still has cash bonds. In Illinois, we eliminated cash bonds through Safety Act. So two things happen. There's no longer bond hearings. They're called detention hearings. And what happens is if you're charged with certain felony crimes, you're going to be taken to court, and a judge is going to make a decision. Either he's going to hold you in jail pending trial, or he's going to release you pending trial. So Wisconsin still has a bail system. So the $100,000 was set by the judge for whatever reason, because I'm not familiar with the case. But just to tell you that every state has different standards of how they conduct their bail hearings. Illinois just is one of the few states that has this no bail Safety Act law going in. So you got that part right? Are you there?
But I don't understand how you can be on bond if you open fire on a police officer, and not just one shot. He unloaded his 9mm.
You know what? That's a great question. I would have to read the transcripts from the bond hearing, because the state usually tries to always incarcerate, keep these people locked up until trial. So for whatever reason, the defense attorney or the public defender representing this alleged shooter made some arguments that the judge felt that the man was able to be released on bond without being a threat to himself or to the community, as you stated.
Okay, because if somebody, a regular person, did it, I mean, you hardly ever see somebody out on bond with a charge like that.
Every state's different, my friend. And Wisconsin, It's a whole different world out there.
Okay, because I know he had a powerful lawyer. I know the guy's got a lot of money, and I know he paid $100,000. I just know so much about the case because I know the guy. I've known him for 20 years, and that's how I know. And I was wondering how the heck he's privileged. And I was wondering, because we have cases like this here in Chicago, and I'm wondering why the NAACP isn't down there in Wisconsin raising heck, like, hey, that's not fair, just because, you know what I mean?
Are you talking not fair to release this man or not fair to the policeman?
Not fair to the policeman because they released him. Not fair to the other people that have similar charges that don't get released.
Okay, you're familiar.
You know
when, Matthew, look it up. When did this shooting occur?
It occurred.
I believe it was.
I'm sorry. Go ahead.
You found it. No, you found it. Go ahead.
It was in. I'm seeing it as recent. Is this? Oh no, it was 2026 last year.
2026.
I'm sorry, 2025 last year. Excuse me.
What month?
January.
So this guy's. So let's go by what we know. It occurred January 2025. I'm sure his bond hearing was within a couple of days of the shooting. So he's been out for a year and he has not committed another crime or has harmed himself. So for whatever reasons was given in the court, obviously this man is not on a criminal streak other than the crime he committed. You understand?
I understand, but that's such a serious crime. How can bond even be? How can bond even be like on the table? How? I mean, you're taking a chance on killing the police officer, the people that we need. So I mean, that's what I'm thinking.
I agree with you.
Wrong.
I agree with you. Anybody shoots somebody who's doing their job in the line of duty. Policemen, firemen. You know, firemen and paramedics have been shot and killed in the line of duty, too. You know this, right?
Oh, yes. And I believe it should be just as stiff of a sentence. And I believe, like Trump, I think he was going to pass a law that anybody who shoots and kills a police officer is like a death sentence. I don't know if he passed it, but he was talking about passing it.
That would have to be on a federal level. And the feds would have to prosecute him like they prosecute. You know, the feds, were you familiar with this with this caper where a man set a woman on fire on the Chicago subway?
Yes.
Yes,
Okay.
yeah, he had just been released on a signature bond, and he was already a danger to other people. So, I mean, this is
No. Let me correct it for our listeners. He was released on previous charges, on not a signature bond, but he's released. There's no bond in Illinois. They either detain him or they release him. So they released him pending trial, and he allegedly committed this crime. He was arrested, but now the state did not pursue the charges because the feds took it over. So the feds are now prosecuting that criminal case at federal court. And that's the last I heard of that. So he's still incarcerated.
Yeah. See, that's the problem when you got a criminal that's all the time repeat offending, and you let him out with, I don't know, you want to call it a signature bond or just a pretrial release. And it's happened again and again because another man was released the same way a few months ago, and he was going around punching women in the face. You heard about that case, right?
No, say that again.
There was another man that was released on pretrial bond a few months ago, and he was convicted multiple times in the past. And when he was out on bond again, he assaulted like 3 or 4 women downtown Chicago. Strangers he never met, just walk up to them and knock them out for no reason.
You mean he punched them, right?
Correct. Yeah.
Yes. That's, you know what? That's happening very common in New York. That's a big thing. And the common denominator, not that it hasn't occurred in Chicago, the common denominator is that these men are attacking women that are walking down the street, women they don't even know.
Exactly.
I could see if it's a dispute between two people that know each other. I understand that. You know, it gets physical. But these attacks on women walking down a crowded street, and there's other people around. It's not like in a dark alley. Broad daylight and nighttime, it doesn't matter. It's on a crowded street, on a public street. Women that don't know these men are physically punched in the face for no reason. And you know what? If you hit somebody in the right place, you could blind them. You could cause a concussion.
Definitely. And one of the problem is, like, again and again on the news, these people commit crimes, and the judges, they let them go on pretrial release, saying, oh, go, it's okay, we're going to give you an ankle bracelet, and they go on to commit another violent crime on a stranger. So I don't know when they're going to get rid of this pretrial release, or at least if you're arrested for a violent crime, there's no release. You wait, you do your trial. That's what I think.
I want to make a slight correction. You're going down a right alley, but it's some judges release these people that commit continuous crimes. Not all judges.
Yeah, I don't mean all judges. No. Most 99% of judges are good. They do. There's just a couple that let them go. I agree with you. Yeah, but the ones that do, there should be. I mean, for a violent crime, you sit your time. You wait in Cook County Jail, and then you go to trial. I mean, that's what we need.
Right now in Cook County Jail, I think we have over 4,500 people awaiting trial. And these are not people who have been convicted. These are just, there are some people who have been convicted. Let me explain that. In Illinois, if you're convicted of a misdemeanor, which means you do less than 365 days, less than 1 year in incarceration, you do it at the local jail, which is Cook County Jail, King County, DuPage, wherever the crime occurred. So there are people in the Cook County Jail doing some time, but the majority of them are pretrial detainees. And what that means is they're waiting for trial. And whenever you get in the court system, and Matthew, you'll know this, when there's a continuance, it's always a month or 2 months down the road. Mm-hmm. Even I've known DUI cases that take 3 years or more. This is a misdemeanor traffic DUI, not felony. So you've got people charged with felonies such as aggravated battery, arson, murder. that are awaiting trial. And you know what? There used to be a site for Cook County Jail where we could actually see how many people are in there currently awaiting. So we'll look it up on the second half as we go. But you make some good points. But like I want to clarify, some judges have let defendants go, and these defendants have committed continuous crimes. But you are you're making some key points there that I have to agree with.
Thank you, sir.
Hey, what was your name?
Patrick Gillison.
Thank you for listening, and thank you for joining us on this first half. But did you understand what I'm trying to tell you? That some of the stuff that happens on television and trials is some of it is pretty accurate, and some of it is just totally far-fetched. People cannot take those trials for gospel on television. You understand?
I understand that, yes, yeah. Kind of like Matlock. He used to go to trial and stuff like that. Yeah, television is a totally different ball game.
Yeah. If people want to follow a trial, the Court TV is the best. Matthew, you watch Court TV periodically?
Oh, I love Judge Judy.
No, not Judge Judy. Please. As we go.
Okay, my friend, I'll let you guys go, and I'll wait for another call. I'll be listening.
Thank you, Patrick.
Thank you.
Okay.
How much time before we go to break?
We got 30 seconds. We have another caller on hold. I'll call him off the air.
We'll get him on the second half. We'll talk to him during the break. Don't hang up. We're going to be back in, 4 minutes?
About 5 minutes.
About 5 minutes after the news break. Stay with us and follow me on my Facebook, Pelarenos Police Project. Thank you. All right, welcome back. We were discussing fact versus fiction on trials that are shown on television programs, not documentaries, television programs such as daytime soap operas or nighttime television such as Law and Order. And I was given my 2 cents worth on a trial I watched on the long-running General Hospital. Mm-hmm. And there seems to, sometimes these television programs are taken for gospel by the viewing public, and that should not be. It's just a program. Drama, that's all it is. So we got another caller on the line?
We do.
Who is it?
Hi, welcome to the show.
George.
Here we go. It's George.
Hello,
is this George Hood?
It is.
Oh, George Hood. For those of us that don't know, George Hood was my guest back in December?
I do believe so.
Yes.
And he is a, you know what? You're calling in on the right program. We're talking about trials, and you were a Tribune reporter for 30 years watching trials, right?
15 years, yeah. Maybe before that for copy newspapers. But yeah, I started off as a night police reporter way back in the 70s in Milwaukee Journal. And so I've been covering cops, courts, crime ever since practically. So, but I was interested in your previous caller, he talking about the bond issue and bail bond and what's going on in Illinois on that. And specifically, he brought up the attack in November where a defendant named Lawrence Reed poured gas on a woman and set her on fire on the Blue Line subway. And that was in November. But he was indicted by a federal grand jury on terrorism and arson charges. So he remains in custody and is not going anywhere anytime soon. But I think for most people, and I think it should be part of any civics class or high school education, a student should go and sit in a busy bond court for a day, or at least a morning, right? That's when it's usually very busy, and just see how the process of justice in the U.S. or in any state in the U.S. begins. Because you get, you've been in bond court many times, Bill, and you know that some of the people, I mean, they're up there before the judge. They look shell-shocked, some of them, and sometimes they should not be given bond, should not be released, and the judge has to determine if that person is going to be a menace to society if they are released. So, and how they determine that is by previous records and stuff. but you never see much of that on the television dramas, right? You don't see that sort of like really messy sort of justice procedure that judges have to determine. I just thought that, yeah, you're right. And Bill, you got to stop watching those daytime soaps. I don't think they're good for your.
Well, I told you in the beginning, if you listen to me, I DVR'd, I recorded, and then I skip all that other stuff, all this bedroom and cheating on each other, and I go straight to the court cases. And I'm going in blind because I don't know nothing about, these characters. And I'm just sitting there just like a juror, and I'm watching this as the evidence is presented to the viewing public. But sometimes, you know what? Sometimes it's a farce, but sometimes on those cross-examinations, whoever they had as writers really hit the nail on the head on 2 episodes that I watched for the past year. And the reason I watched it was because of you were asked. So let's see. In years ago, I used to watch Law and Order because my wife liked it. But I tell her, hey, I don't want to watch these police. The first segment is the police investigating. The second segment is the trial. Are you familiar with Law and Order?
Yeah.
Okay, that's how they had broken down. The first was the police. The second was the prosecutors taking the evidence to trial. And I used to watch it. I watched it for about 6 months, but I told my wife, hey, does a plumber want to come home, watch a plumbing program? I live this stuff. I go in court all the time. I'm making arrests. I really don't want to watch it. I'd rather watch a comedy. Last night I was watching Groundhog Day,
There you go. That's a good one.
We're going to have a Groundhog Day program in February too, Matthew.
Okay.
But you know what? You were in court many years. Courtroom procedure, and I think you'll agree with me, varies not only from state to state, but from county to county.
Right.
Would you not agree?
Yes. It's a very uneven sort of system where Cook County will have different court procedures as opposed to McHenry County or Lake County. It's not really, a lot of times they're very subtle, for instance, and usually it depends on how busy the court is and how many defendants have to appear in the morning. So sometimes there is kind of a rush to justice, right? And a judge may not be fully informed of a defendant's past history. And it's much better now with the computerized systems. But I think that, bail somebody in Cook County for the same, let's take shoplifting, a very common crime. In Cook County, somebody will get released. In McHenry County, somebody will get, they'll be in jail until they can post $1,000 bond or something like that. So there is that. There is a wide variety of, and a lot of room for a judge to say, bond might be $300 in one case. And in McHenry County, it might be $1,000.
But George, there's no more bonds in Illinois. We got the Safety Act. They eliminated it's detention hearings now. They're either detained in jail or they're released pending trial. They don't have to post no more bond.
Right. Well, I'm only speaking from my personal experience.
Yeah, you're talking about past cases. Yes.
Yeah. So. I think, I don't know the background on this Lawrence Reed case, the guy who set the woman on fire in the subway, but he had 70 prior arrests or something like that.
Yes, that's true. But the feds took that case over, so now it's a whole different animal. He's being tried in federal court as opposed to state court. So they're holding him. Now, when we get to trials, and this is interesting, and you'll agree, the state court rules of trial are different from federal court rules of trial. And it differs with military. So when there's a court martial, that's different from a federal case or a state case.
Right.
It's for procedure.
Well, yes, and there's a big difference between misdemeanor and felony, as you previously discussed. A misdemeanor case, be a signature bond. They don't even have to do that anymore if it's a shoplifting or, say, possession of small amount of marijuana, which is not a crime anymore, actually. So, but I think watching the bond process in court, and you would see some people being held for a shoplifting offense, say, and without the means to pay for a bond, post bond. And generally, I would have to say most judges would just say, well, this is not a conviction. The idea of bond was just to ensure the appearance of a defendant in court. It's not like a conviction. A lot of people think people should be held just because they've been arrested for something, but bond is not any indication of guilt or innocence. It's just an insurance that people will show up for their court date. I don't have any recent stats on what's going on in Illinois on that count, but I think it's an experiment that still has to be looked at. What do you think?
Well, you know what? Me and you have been in this system, in the legal system, for decades. And what I got to tell you is there's no perfect system. I don't care what state you go to, what even other countries. We've seen there's cases in other countries where an American is murdered or disappears, and we see how their system handles it. A very famous one is the Natalie, I think her name was Hathaway in Aruba. Am I correct? Was it Natalie Hathaway?
Right. Natalie Hathaway, yes.
She was murdered in Aruba. She's been declared dead. But they had a suspect, and they couldn't keep him. They couldn't develop the evidence. Whatever their procedures were, this guy was allowed to leave their country.
Natalie Holloway.
Holloway. I'm doing that from memory, but thank you. But this poor woman was abducted, probably sexually assaulted, and definitely murdered. They didn't find her remains, but the way Aruba was handling it, the family was very upset at the time. There was a lot of media coverage in the United States about this case.
I remember seeing it when I was a kid. I recognize her instantly.
Yeah, I've been to Aruba. That's one of the few countries I've been to. Yeah. And it's very small, and who knows how much training they have in handling homicides or missing persons presumed to be homicides. But whenever you go to a foreign country, the rules of the United States go out the window. You know that.
Yeah. Yeah. Well, that was in Aruba, Dutch. It was a Dutch possession. And that was, I misspoke. It was a 2005 case where she disappeared. And she's eventually declared dead 7 years later. But that was Vandersloot. And he, and there was two other people involved in that who were implicated in her disappearance. But yeah, that was, he was released. They didn't have evidence to,
I believe he was convicted on multiple murders. Matthew, pull that back up on Natalie Holloway. He's got it on the internet here. If you're following us on YouTube, pop that up. Or what does that say, Matthew?
It says here, quote, excuse me, she was an 18-year-old American high school graduate. Her disappearance resulted in international media sensation. She disappeared. It was May 30th, 2005. And then let me see. It said that status missing for 20 years, 7 months, and 10 days, declared dead on January 12th, 2012. So it's coming up to that anniversary soon.
Yeah.
So it took
He
7
was-
years to declare her dead.
Yeah.
Yeah. But he was also convicted in Peru of murdering a woman there, I believe. And I don't remember when that occurred. As after the Holloway case. Yeah.
Go down
So,
to
anyway,
conviction.
Conviction.
Wait,
Jordan Vanders.
there he is.
Yeah.
So the suspect in this case was a guy named Vandersloot, as you mentioned, and I believe
Yeah.
he pled or he's made some admissions to the murder. Correct?
Yes.
Yes. And also the Calpo brothers were also arrested on suspicion of the
Yeah.
kidnapping.
Friends of his.
Yeah, but that was a bad case because that was a case of a girl on vacation. She's in a foreign country. She's been drinking. And that's a common denominator because people, when they're drinking, they let their guard down. And it impairs their judgment. And who knows, how they were able to coax her to take her wherever they took her. We'll never know the answers to this. So it's just a tragedy. And we put out information. We cannot do anything about what's happened in the past. We can just use the past to protect future victims by telling them, don't go down this route. You know what I'm saying?
Yeah.
Yeah, so that was my whole point to that is here's Aruba. They got a whole different set of standards, courtroom procedure, how they operate, how they interrogate suspects, as opposed to what's going on in each individual state of the United States.
Yeah. You cannot be too careful when you're overseas, right?
Can't be too careful any place, but I trust law enforcement in the United States better than I trust in these foreign countries.
Yeah. Yeah, I would have to agree with that. There's been, several cases like that. In any case, the portrayal, back to the original topic, the portrayal of courts on television are pretty warped unless it's a documentary of some type. And we want to include movies in which, there's a court, say, A Few Good Men or that
Yes,
type of
yes.
thing.
I was going to bring that up. All right, the film is Matthew. Go on YouTube, not YouTube, Amazon, and go to A Few Good Men. It's available on DVD. I always recommend people to either stream or watch this movie because out of all the courtroom movies that I've seen, this one has some key points. First of all, Tom Cruise, who plays the defense attorney, has a great line in this movie. And what he says is, it doesn't matter what the truth is. It's what I can prove in court.
Yeah.
You know that,
Right.
Because even if you have some evidence, as a reporter following cases, there's something called the motion to suppress evidence. Evidence can be suppressed. The jury may never hear this evidence.
Right.
So it doesn't come into play in their decision, even though it's evidence.
Right.
And sometimes you know something, but you can't prove it. You have to have some kind of a foundation to get that evidence in a court.
Yeah.
Even on civil cases. And let me give you a great one. A few years back, there was a man involved in a traffic accident. So I was driving down the intersection, and this is like the year before I retired. So it had to be 2011. And I'm driving down the intersection with a squad car, and I see people videotaping the intersection. So I just stopped out of curiosity. I mean, they could videotape all they want, but these were big cameras. It isn't like somebody with a cell phone. So I was asking, just out of curiosity, I don't mean to bother, but what are you doing? It turns out that there was a serious personal injury accident at that intersection the week before. So they went to the same intersection at the same day of the week at the same time and started videotaping the traffic lights, the traffic, everything to try to get a similar basis to bring into court or at least in the depositions on this civil case. This is what traffic is like on a Friday night at 11:45 at the intersection of, let's say, Rand and Dundee. So they are creating evidence, and whenever you document evidence like that, video or photography or even interviews, the person that took the pictures or the video has to testify to it in order to get that evidence into court.
Yes. And even if that evidence may not even be admitted. I mean, a defense attorney, or the prosecution, either one would say this is irrelevant to the case and has no bearing. So it would be up to the judge to rule on that, whether the evidence would be admitted or excluded from the trial.
That's what I'm making. That's the point I'm making. It's evidence that's created or presented, and there's an argument, there's a motion, and a motion is a hearing for those people that don't understand the legal system. And the judge determines, will this evidence be admitted to trial? And that's what it comes down to. So even if you got you got to have witness statements, you need to get the witness in the court. Now, there have been exceptions to the rule. As you know, there have been deathbed confessions and deathbed statements that have been admitted into court after the witness or the subject has passed away. You've heard of this, right?
Yes. What was it recent? There was a case like that not too long ago. Can't remember it right now, but but that can be it can be admitted into court usually if it's verifiable, right?
It's there's a term for it. We're gonna have to get a lawyer here because we're gonna get deep into the legal system. But there's a term for it about these dying statements. But I know many cases that they've been allowed in. And look, let's say I'm shot and I'm bleeding to death, and the officer, the paramedic comes and I say, "Matthew shot me over here. He didn't like my show today," and I pass away. That statement is brought into court by the paramedic or the policeman or the witness that heard it. End of story.
Yeah. Well, sometimes it doesn't even depend on evidence. Sometimes it depends on appearance, as in a jury trial. And I remember covering a murder trial of a young woman charged with murdering her live-in boyfriend, partner, right? And they were both engineers and had really good jobs and stuff. She's charged with, during an argument, stabbing him once in the chest, and he died. And during an argument. And so she was charged with murdering him. And I remember going to the trial. She had a public defender, Cal Aguilar, who was really a good attorney, good public defender. But and I thought, well, who knows? It's a jury. It could go either way. But she walked into the courtroom. She was being held without bond. And she walked into the courtroom, and she looked like she was 14 years old, and it just was going to church, right? And I immediately knew the jury would never convict her. So, sometimes cases like that, no matter what the evidence says, she picked up a knife and stabbed him. Now, is there intent to commit murder? Yeah, you can create intent in 5 seconds, right? Or that you develop an intent, you're going to kill this person.
There's cases, and I agree with you, that falls to the sympathy of the jury, or they're sympathetic towards the defendant. But we're going to get deeper in that in a future episode because we got 30 seconds left?
50.
15. George, thanks for calling. Hey, we got to get you back on here live when you feel better, okay?
Okay.
All right,
good.
thank you, George.
All right, Bill.
Join us next week on Life Experiences with William Pelarenos, right here on WRMN, 1410 a.m., right out of downtown Elgin. Thank you. Have a great weekend. Bye-bye.